to order. I believe we have a quorum present. I'd like to thank everybody. Thanks to everybody for being present today. We have a couple of items on the agenda. And the first one is to discuss and consider a resolution considering options for the ATS camera safety program. And Judge Wiley, do you have any information? I have 3 people that have signed up to speak. Would you like for me to let them speak first?
Sure. Your pleasure. You're on whichever way you want to do it. It's fine.
Okay.
That's great.
All right. First is John. Put you in alphabetical order just so everybody know. The first is John Cook, and he wishes to talk on the ATS cameras.
Thank you, Judge. Thank you, Commissioners. I appreciate being here too, just like you guys probably do. Here we are once again discussing the financial cancer to our county, our contract with American Traffic Solutions. Several people appeared before this court before this hellish contract was entered into, and practically begged the court not to enter into this contract. In all fairness to you commissioners here today, there was 2 that were here that are not here anymore, Clark and Manning. But anyway, Jimmy Brzalik and Ken Shane voted against entering into this contract. However, Judge Wood, with those 2, voted for it. Judge Wood, you and a lady representing the ATS both said there's not going to be any cost to the county. What has changed and why is there now a cost? We took you at your word. As I recall, Commissioner Brzalik pointed out the specific paragraphs which detailed the cost to this court as well as to County Attorney John Long. Was County Attorney John Long working for Bickerstaff Law Firm at the same time he was our county attorney? And then was Bickerstaff representing ATS in this contract? I urge you to seek an opinion of the Attorney General's office on the legality of this type of operation against our citizens. If there are problems with the legality of this contract, then perhaps we could have ATS collect their toys of debt and place somewhere else without having to pay them any more than we already have. Please ask for the AG opinion. If you are not going to hide anything, then I think you will. And I would appreciate someone looking at this that has the ability to really know the law as far as the state is concerned. So I want to thank you guys for the work you do, and thank you for listening to us naturally. So thank you.
May we have a copy of your comments?
I can get you a copy.
Okay, that'd be great.
Each of you?
Pardon?
Each of you?
That'd be fine.
Okay.
And if you want to get it to me, I'll make sure every commissioner gets it.
Thank you.
Whatever you'd like to do. Let's see. Next is, I believe, Ms. Josie. You came in. You're next in alphabetical order. And you'd like to address item number 1 on the agenda, the ATS camera safety.
Yes. Thank you, Judge Wood and Commissioners. When Commissioner Brzalik, when you spoke out against this program, you were right all along. You pointed out from the beginning that this was going to be an enormous cost to the taxpayers, and it appears that the day of reckoning is here. Judge Wood, you were wrong, and it appears that you lied to all of the Kaufman County citizens about there being no cost. The proof is in the meeting here today. Given the recent ruling of the Texas Supreme Court on the red light cameras in Richardson, I think it would be a financially prudent thing to do to request an opinion from the Texas Attorney General's office regarding the legality of this contract. If their opinion is that it is not a legal contract, then the taxpayers are spared from the outrageous and egregious penalty for getting out of this contract. If they rule it to be a valid contract, then do what you must to stop the hemorrhaging of our tax dollars, taken from us by force. As our elected officials, you are supposed to be working for our best interest, not that of ATS. If this keeps just one citizen from losing their property due to taxes they cannot afford, then it'll be worth the wait for an opinion. Thank you.
Thank you. And I likewise, if you would provide, if you don't mind, a copy of your remarks, so we could have them for the record, that would be nice as well. Next would be Ray Myers, and he also wishes to address the ATS camera issue.
Thank you, Judge. Thank you, Commissioners, for your time. Appreciate the invite to come over here and speak whenever we have a concern. I was here in this courtroom whenever Kaufman County Commissioner said that it wouldn't cost us a dime for this ATS contract. Well, we found out that down in Smith County spent $46,000 just in legal fees just to get this contract going and get it through. That's not exactly what we heard that day. Now, Judge Woods, the courtroom was packed when you told the citizens that we wouldn't have to pay that. In Houston, and I quote from this newspaper article, ATS no doubt wants that money to go to the court and get it. That's what the company did in Houston after the voters then banned the red light cameras. They voted to ban it in 2010, suing for $25 million in damage. It ultimately settled with the city for $4.8 million. Baytown also sued, and they finally had to settle for $1 million. The perception is the contract is illegal to start with, and we beg you not to sign it. As for me, I don't want to see one penny of that money to go to anybody in ATS. I'd rather it stay right here in Kaufman County where it belongs. One final question, how much money is that going to cost us? We really want to know, and at the very least, we want an AT opinion. We do want that opinion. Appreciate your time.
Thanks, Mr. Myers, and also if you don't mind giving us a copy of your remarks.
Okay.
When you have a chance. Ronnie Oldfield wishes to speak on the ATS camera safety code.
Thank you, Judge. Thank you, Commissioners. Thanks, guests. You know, Acts 4 relays the story of John and Paul's appearance before the Sanhedrin and the Pharisees to give an account for their healing of a man who had been crippled since birth for approximately 40 years. After giving their defense, Peter and John went back to their church, the first church, and the church started praying. And part of that prayer is recorded in Acts 4:29 and 30. And now, Lord, take note of their threats, and grant that your bondservants may speak your word with all confidence, while you extend your hand to heal. And signs and wonders take place through the name of your holy servant, Jesus. You know, paragraph 4.1 of the contract reads that ATS shall establish a dedicated bank account, the dedicated account, into which receipts for violations will be deposited. ATS shall withdraw and retain its monthly service fees from the account. ATS shall pay the customer no later than the 20th day of each month the customer's share of the revenue from the preceding month from the dedicated account. Each month, ATS will remit to the customer an accounting of the preceding month's collections and service fees. It's not a direct quote, that's impossible. You know, that provision of the contract violates local government code. These fines and fees were collected through law enforcement of Kaufman County. They are fines and fees that are due to Kaufman County on a 100% basis. I've consistently, gently made this point to the court that the court must resolve ATS's failure to deposit 100% of the fees collected with the county treasurer. Granted, ATS has the authority to submit an invoice to receive that money back. This is an undisputed fact that this violates local government code. If in the settlement provisions of the contract, my interest is to make sure that ATS complies with the local government code, deposit with the county treasurer the funds collected that have not yet been deposited, so that this process can be forced to comply with local government code. Since this has not occurred today, again, once again, if there's any doubt, our county attorney can submit on behalf of the court for an attorney general opinion. You know, this resolution must take place. The money must be deposited with the county treasurer. That's my dog in this one. Thank you.
Thank you, Mr. Oldfield, and likewise, if you have remarks you could give us, that would be a good thing too. All right, I believe now we'll go to Judge Wiley. Are you going to be the spokes?
We can talk together if you mind
Okay,
to.
yeah, that'd be fine if you'd like to come up. And
Sure.
this will be on item 1, and we're discussing the resolution option for the ATS camera.
Sure. Let me give you a little background. We have items 1 and 2 on ATS. I'm going to give Rebecca a little room up here too. We got items 1 and 2. Frankly, I'd like to speak to 1, and I don't think we're prepared to speak to 2, and that it'll become relevant. Why? As we move forward, because we need to nail down some more specific terms, because I don't want to rush anything if that's the option after going through the 3 with y'all want to go. If you don't want the option of finalizing this through settlement, then I can quit the time between me and ATS. So I want you to know what we've done. Since the last time we talked, you, as the Commissioner's Court, since it's no longer attorney-client because it was said in executive, about the amount to settle, because I can hear the concern. I think it's a righteous concern. I'm not taking issue with the community, but it was clear that the Commissioners did not want to enter into a settlement that exceeded anything that was the net proceeds. And so one of the things I had to do with the auditor is to get that number, because it was a moving number to me. I didn't know, what the number was, because I really never looked at that account. So I would say approximately the net proceeds that we have received is $200,000, $198,000, I think is the number I saw. And the settlement that y'all approved would have to be under that. That was the marching orders I had. And I don't even remember when that was. It was maybe 2 or 3 weeks ago. So with that was working out what that would be, because as y'all pointed out through other people maybe here in court that we didn't want to pay over, you've got stories of how other people would pay millions. And we've all agreed that potentially that could happen, perhaps. I mean, anything's possible. So settlement seemed like an idea. But I also want to talk about some other options that I've heard people in the community talk about, and then we'll go back to the settlement agreement, and of course, the decision of what to do and how to go forward, and to leave it to the lawyers to finish up the terms. We will tell you the pros and cons, where we think we are with the settlement, and then tell you the pros and cons of the other ideas. So let's walk through what I believe to be 3 options. One thing I want you to do that was said, and I think it's righteous, the Attorney General of the state of Texas is our lead law enforcement in the state as far as attorney, and so I'm not putting my credentials against their office, but I think I can read the law and understand it. Some people may take issues since John Long did work for me at the time, and y'all disagree with that. So I'm just going to give you what I believe is my reading, and with Rebecca to join in. Also, we have had a contract that you guys had agreed, and under that contract we went and win because this is so important. I went back to them to go over the settlement terms because I wanted another set of heads on it. I limited them to 10 hours because I know with the bill, we'll see how that turns out to go back over so there's anything we mess. So I want to know you to know the weight of which we've given consideration and the other players, but not the Attorney General, to be fair. So I think one of the options, and I believe Commissioner Rosales had talked to Rebecca, which gave us this option, so I appreciate that. And I also believe he either relayed, or Commissioner Shane relayed it to Rebecca, the option, and I want to make sure I say it right, basically, and I think I've heard some, perhaps people that support that position, requests an Attorney General opinion regarding the constitutionality of the program. So let's just say, and we have some reason, I'm not commenting, what the Attorney General would do, and I know the Attorney General cannot comment on what they would do, because it would be unseemly to comment on a decision before it's submitted. Nobody can tell you that. If they did, you can't rely on it. Well, what you can rely on legally is precedent. In courts, it's called stare decisis. It's the same principle when you're talking about an issue with the Attorney General. So we can assume, not based on what they said, based on the decision and opinion that they gave, an Attorney General opinion that I believe that I got through email from Rebecca regarding an insurance camera that was set up. And in that, the Attorney General has found that to be unconstitutional. And so we know from the history that the court is leaning that way. So I do believe that that issue is right and could perhaps be favorable. I don't know, but good sense says that's not a bad option for that. So let's say you get what you want. You get, or what some want. I'm not saying anybody, I'm just saying collectively as argument. What do you do with that? That doesn't turn the cameras off. That doesn't stop the contract. In fact, what you do with that is you do a declaratory judgment in court, okay, stating with that declaratory judgment that it's unconstitutional, and that's how we would proceed, and we have to have a court make that decision through the declaratory judgment. We would have an opinion, and as you all know, the Attorney General is not a court of law, it's not the legislature, and we don't need to bore y'all with the history lesson about the three branches of government and how they all coexist. So it's from the executive branch, and we've been giving an opinion through their executive decision, and we can rely on it and we can use it for persuasion. And frankly, I think that from the prior legislative, 2 years ago, I think this is something that's on the move. I think other people are seeing this and it's on the move. To see this in county, it's unworkable. We've got Mr. Oldfield that spoke about an issue that I think they cannot resolve. I think he is absolutely right. It is unresolved on the constitutionality issue, for an example. But we would still have to take an action with that. And I just want to remind folks, as a lawyer, you can get something as a layperson. We get the Attorney General opinion, but we got to act on it. Now, we could not act on it, but then we're waiting for them to do nothing. Are we in the same posture? Are we just waiting? Do we expose ourselves? So we walk through that. What I don't like about that the most is not the Attorney General opinion, because it has nothing to do with that. Because if I was a betting woman, I'm not, because I have kids in college and I can't afford to bet, and it's illegal in Texas, is that I would say it might be favorable. But we would have to act. And as we act, we lose the cloak of sovereign immunity. If you understand what I'm saying, it's football season. Are we going to play offense? Are we going to play defense? I like taking things offensively, but when you take on offense and you clear a deck action, we do lose our cloak of sovereign immunity by bringing that suit. And that's a problem that I have, and I can't reconcile it, and I've thought through it. The ATS won't follow declaratory judgment because private parties cannot circumvent the state's sovereign immunity from the suit by characterizing the suit for money damages, such as a contract dispute. So they're not going to do anything with it. So there we go. We got an AG opinion. We're right. We won the moral high ground. It could happen, but what happens? Okay? That's just, and so I just think about that for a while. Is there anything I'm missing into that one?
Other than if you were to actually file the deck action, the contract,
And I mean declaratory, so make sure you're clear.
it would still exist. So if the court found that a piece of it was unconstitutional and it was an integral part, and we think that it would be, then the suit, with the contract, they would then break it apart, but you're still open to damages and you're still paying them for litigation expenses. And because it's so integral to their business model, we believe the litigation expenses would be quite numerous and that they would be repetitive. So they're entitled to, if they got an unfavorable deck action, which would be good for us, they would have an interlocutory appeal, which they could then take to the Board of Appeals, and then in some instances that can actually go to the Supreme Court. So you just have to be able to look at the litigation expenses that would go alongside that.
And we can ride that tiger, okay, because these are your decisions, because I think sometime in the past, you know, we've gotten a way of saying, y'all do this or y'all do that, okay? We can't think of every possibility, but be clear that based on the precedent with the AG, I don't think we'll get a bad outcome. I don't know that. I want to be clear. I have no idea. We know it based on a prior decision. The result of which, will that help us? Because then we have to act on it to get us what we want. And the big problem, what I believe Mr. Shane has pointed out, and well, all of you guys, all of y'all, including Judge Wood, is the damages. And so we don't lose the damage provision if we go that way, potentially. Because they're gonna be defending their business model, and they're gonna defend it the whole way, dragging us through. And that's fine. And we can send this to another lawyers who spend a lot of money. And of course, the converse is they may do nothing. They may say, okay, we've got this, things are so bad, we're gonna do nothing. I don't know. I'm just giving you all the potentials. Another thing is unless there's something else in there.
Actually, damages under the contract.
Yeah.
Even if you,
Yeah,
even if you dissolve the terms, you'd still be subject to some type of
damages. And y'all have run those damages number through. Because I think the way to say it simply is you might win on the Constitution issue, but you still got all your damages issued. You've only got one part of the contract that you won on, but you still got everything else to open up. That's the only problem with that. But that's, again, your choice, and we'll field questions. And, you know, Rebecca's worked closely with trying to get these terms. Once we got your approval with the amount, then we were able to go forward. We got a few things, and we want to know which one would be dispositive that you want to nail down. The other one, and it was really just a thought, I think either y'all said it, or when we talked to the attorneys, and I'm speaking of when, their other option, and they went with pros and cons, is really turn it off. Just turn off the camera. Do nothing, really, and turn off the camera. All collection activities would cease, which means that we would be able to limit somewhat our statute of limitation, because it would be from the point that we stop, maybe. Yeah, set someone pays, yeah, you're right. Now, us turning off the cameras would constitute a breach. So we would be in breach of contract. If we're in breach, the county's waive sovereign immunity as a defense to liability under the contract with ATS, but it's not waive immunity from suit. So we've got two things we're looking at in that, okay? Go ahead.
So what they would try to do is, they would argue that we're in breach, and they would try to force us under the contract either into arbitration or try to sue us, and we would continuously have to try to play the defensive move and say, well, we have sovereign immunity, we sued, we did not waive that. That can only be waived through the legislature. So it'd be kind of a waiting game for a period of time until you have to wait out your breach of contract statute of limitations.
And your breach of contract is going to be a little bit longer than what we were talking about conversion. I mean, we're talking a 4-year on a breach or statute of limitation.
The same litigation prices would you need to configure those in this one as well.
They'd be attenuated with that. You know, there's all kinds of things we can imagine. In the breach, when they sue us, they're going to talk about depreciated equipment value and money and actual damages we talked about. And they'll probably keep the funds that they have right now in our joint account, and we won't get any of those, because if we're not playing ball with them at all, they'll just keep whatever they've got, so we won't even realize where we are. So that's another option, and that's another viable option. At least we're in a defensive posture there instead of an offensive posture, and we will continue to argue immunity. Make some people nervous just to be waiting for somebody to do something to you, but you guys can do that now, button. We're good with telling you the pros and the cons of that.
Each option, you just have to weigh the price.
Yeah.
You're looking at the damages in the account plus the litigation expenses on that one.
And then finally, I think because this one is the one that you kind of, and to be clear, for those of this is to the public, to be clear, you didn't say, y'all, you settled this, but I can't come up with a number. I don't have the authority to come up with a number. And so they came up with a big old fat number, and I'm like, no way. So the number that they countered and agreed to was half of the original number. Not that I think I'm great with negotiations, I think they're regular unions. So 175,000 is where, if we give them 175,000, and yeah, it's part of the termination agreement, plus 6,800 in removal, that we at least came up with a number, okay? And they're in agreement on the number. But there's other parts of it that's not final, but I weighed not coming and explaining it, and knowing that people in the public want to hear this, and there's no reason to hide this, it's all public information, that there's some things that we've got a wind down period of 90 days from the termination date, mutual releases, we've got indemnification at this point up until January 31st, 2017. Once the indemnification period ends, there's a mutual release of claims to be signed. So we're done, they're done, and it's all over. There's a second final release of claims that would be the only surviving document. We'll talk about that in a little bit.
The one piece that survives is that we can't consider putting into their software.
Yeah,
we
we don't want to do that.
proprietary for them, so they keep their software.
They can have it.
Yeah.
And we did little things like we were negotiating like, okay, we can't be running back and forth with these people. I mean, we need to make sure y'all want to go that way, just to give us that direction, and then we'd have to come back and tell you if there's any pros and cons in the contract. There's some pros is we're in control. You know, at least we're in control. We're knowing the number. You know your number. But let's be honest. You know, I know a lot of you guys have said, and then I can hear people, we don't want to pay them, and I get it. But I'm just saying, we're not paying them anything if you look at the net proceeds. I would rather pay them nothing, but that's not how business works, or that's not where we are. Now, if y'all want to change it, the matrix on that with us, with the number, that's your call, and I don't know how successful we'll be, but I think the number's fair because they know what our net proceeds are. So when they came, you know, they were going to try to double us. Now, I'm pointing to Karen, she gave me the number, not because she didn't even do it, but she doesn't know what it's the same. So when you look at the number, they were going to double it on us. I'm like, no, come on. But we can figure out how much we've made in it. So, you know, we still haven't got whatever proceeds may still be coming in. There's no affirmative finding made about constitutionality, which helps us later, really, as a county with third-party liability that we face. You know, to be honest with you, just hearing the sentiment, and maybe this is worth something. Some people, if you're looking at it negative, I mean, maybe ATS gets to feel like they got off the hook, they pulled a fast one. I mean, I can see that being a concern. It is what it is, and this is. They're not pulling anything. There's no, at the end of this, in 10 years they come back, it's done. It's a mutual release. ATS is out. Are there, and one is an offense position, and that's the only reason, because I had a couple people when I walked in and go, well, we just need to get that agility. We can get it. What do we do with it? And we can get it and sit on it. Kind of like still get it and sit on it. Or we can don't do anything and turn it off. Or we can continue to resolve and work on this, and I would say we're 90% there, but it's not fair not to let y'all know where we are and not to make a decision which way we want. And that's where we are. There's something else I forgot about the number. I mean,
Of course, you have questions, you want to have questions.
Well, that's a lot there. Maybe it's a lot there. I guess the bottom line is, when we talk about, well, we don't want to spend money on it. And I think everybody's got to totally understand. Everybody has to understand. None of us want to spend money for these people. It's not even a question of that. We're all there on that same page. What everybody would like is for these people to go away. And the bottom line is what it actually takes to make these people go away.
No.
You know, so the bottom line is how they go away. If we
Give them money out of our net proceeds instead of making $200,000 on this deal, or no 198, we'll end up making $25,000, which is not, as been pointed out before, doesn't near get to the fixed cost of police time, my time, whatever, but we work on the nickel or whatever. But I'm talking about just what is in that line item and what's, I'm not in any way poo-pooing, you know, the time and energy that's been spent that's fixed. I haven't crunched that number. But some of those costs would continue as we wait on the defense on one, or just wait.
while we're waiting, what happens?
Well, it
I mean-
depends what you do.
Yeah, because one thing, what I understand is that no matter what, no matter which way it's moved, the AT, is in our paper, their paper, it still makes no difference, it's an opinion. So you still have to go to court. And you go to court, you go on separate issues on the contract.
Right.
And so,
Yeah.
some of the contract can be deemed, you do owe damages and you do owe them.
Right. That,
Then we have to go to court.
right, that's the only problem. The AG opinion or the doing nothing opinion, which are two viable options, we still have to act on it. And, I mean, we don't know what's gonna happen coming to the legislature. So we don't know what's gonna happen, and we might, you know, we don't know. But all we're doing is controlling what we can. And the number y'all said to look at, you said the only number I could look at to settle, because I wouldn't even be here, I'd be saying, well, here are two options, is it has to be under the net proceeds. That was what you told me. So I pulled the net proceeds number, and they came under it. Of course, you know, they've got an account in their spot. They know exactly what they've made off of us. So, you know.
Since we last talked about this, are you aware of the Hayes County lawsuit?
No.
Filed?
No, I wouldn't.
You know, Hayes County is, I guess, the third county that's participated in this.
Okay.
Um,
Now, who sued who?
I think there's an individual
Okay.
that maybe is forming, or has filed a class action lawsuit against Hayes. I think they did a 2-year contract on this.
Well, good for Hayes, because they've got identification.
So that, could that opinion, I mean, surely that opinion would be relevant on our case if the judge comes back, just like the
It
ruling
should.
by the judge on the red light camera, that
Right.
surely would help
Why
us.
not? It's so liable to indemnify us,
Yeah.
because we're in a contract, so that's a.
Yeah, I'm just saying, Hayes is in a good position. If they got a third party that sued them while ATS is involved, they have indemnification contract standard and all, because they want to defend the business model. So, to answer your question, I want to be careful what I answer you. Yes, it could help. I don't know the life of that case. I don't know how long that would be. And B, Hayes County's sitting pretty good, because all they can do, if this was Kaufman, I'd say like this.
Stand by.
Y'all do. Y'all figure it out. And if the citizens win, yay. 'Cause that-
So my question is, surely that could impact
Yeah,
our
but-
position.
Yeah, it's no different though, because you're right. Like I said, the first thing I said was you're right. I don't know the timeline on that, but I do know how lawyers do things. So if they're in, they're gonna be filing summary judgments to kick them out of their contract. I mean, I don't know what they're gonna do. And I'd be just speculating to that life of that case. I mean, I'm talking about a legal case, a legal
Yeah,
lawsuit.
right.
I mean, I don't.
Court time.
Yes, I don't have information on that. I'm just trying to,
Anything that probably impacts option 3.
yes,
Where
the
you're
sit
talking
back,
about the
yeah.
sit back.
The sit back, because I like that position, you know, and then somebody else might even get an AG opinion. Hayes might get an AG opinion. I mean, who knows? It might be one floating around there now. The only thing, you know, the AG opinion doesn't trigger anything for us one way or the other. I just think the problem that we get is, the thing is too, you remember too, where we are under option 3, if we breached and did nothing, we would be in court going without an AG opinion. We are relying on the, insurance case that the AG.
Well, that kind of simplifies things. You know, if we request an AG opinion, meanwhile, this Hayes County thing plays out.
How does it simplify things?
Well, it gives us more options.
How? Which one?
Like I said, if we request an AG opinion, it's gonna take, what's the normal time?
I have no idea, like 3 to 6 months, depends on the thing.
Okay. We request an AG opinion, we monitor this Hayes County lawsuit. Meanwhile, we put these cameras in the parking lot, say, we're not gonna participate in this extortion program on our citizens until we have a ruling and we have a court action.
Okay, and then we go right back to what we have to do, which is what you, was fine, if y'all wanna do it. Option 2 is for us to do that, even with the Hayes County opinion, even with the favorable AG opinion. It makes it easy for you, and that's good. But for me, it just means that you advise and y'all decide, is that we have to act on those opinions, and we have to act on stare decisis, which is former case law, if they make case law. And they get to, just like what Rebecca said, they get to exhaust all their appeals. And those kind of blue-stocking law firms love to not be done in court. But you know what I'm saying? I'm saying all of that, but I don't have enough information. Because Hayes County may decide to sell their stuff confidentially for $20. How do I know?
$500,000.
Or $500,000. How do I know? I don't know anything.
Well,
So that's what I'm saying. I don't know what they're doing in that commissioner's court with those people. And since that's another body, but I will say in consideration of this, that yes, it is something else. It's another piece, just like the AG's piece of the insurance case that's advisory. It's another piece, and if that gives you, a good feeling, I understand. But I'm just saying, as a lawyer, there's so many stops on the road of a case. And I think that the complaint has always been that we haven't given y'all, in these type of situations, enough information. So I have poured everything into thinking what could happen. Ultimately, y'all decide. I don't know. I'm a little OCD. I like to control, but that's not my decision. It's y'all's. And it may be a bad one. I mean, it may be the wrong thing to do. Mike can just be defensive, turn them off, tell them to move stuff, and wait.
In the meantime, there's all the fees, fines, and stuff mount up, and all their debt, and their contract, and what they're saying, about
Sure.
cameras.
Sure.
This ain't up in.
Well, if
No, no.
In the contract, it's approving it.
No, right then.
they're approved no matter what.
Not if we settle, they're waiting.
Well, but they haven't responded. I mean,
No, they have responded. Maybe I misspoke. The number is settled, 175 and the 6,800. There's no whatever's gonna happen. That's it. That's the number, that's the math.
The mutual release.
The mutual release.
Any of those claims.
So any of those, that's the only reason we do it. If we were gonna get caught, there's no way we'd even present it, because we get caught.
Then what are we waiting for as a return for doing right now? Why
Oh.
do we not have this?
One of the things I want to make sure of, one of the things I really want to make sure of is that, let me get this right here, because I've written down some notes, that I would, just that kind of legalese that I didn't like. They had a comment in there on the termination payment in full satisfaction of these removal costs, and this is just some verbiage, and I didn't like that, because it made it seem like they could jack those up. The 6,800 is the removal cost, and I wanted that to be fixed. I didn't want them to just have a general number. I wanted them to say, no, that 6,800 is all removal costs. I'll come back later and go, oh, you owe us another 10,000. So that was something, and we just didn't get that, they sent us stuff, and we responded. It's sitting in their queue, it's not in ours. Because that's why I've been here this morning with Rebecca going, you got anything? I ain't got anything. So we have been going back and forth with faith. The big terms, for me, was the waiver fees, mutual releases, and the number under what you said. There are some other issues that I think we'd have to come back if you choose to go that route. You may not choose to go that route. So working out the little details maybe just wasting time. I just need to know if I need to keep going there. The other thing was, another thing, to limit our statute, a limitation on this, we don't want, when we do the wind down, whatever fees that are at the wind down for these citizens, that money needs to go back. If they collect a dime after the wind down, that needs to go back to the taxpayers. It needs to go back to people, because that just, keeps opening us up on our statute of limitation. So that was another one, and you asked me about what other issues. What is this? Yeah, we would like to either make sure on the identification part, they want to narrow that window, we want to expand that window. They want to narrow how long that identifies, and we want to expand it. And this is really executive stuff, whatever.
I know what,
Yeah.
I know what.
Yeah, I think I've got a workaround that would help us. I think I've got a workaround. But in case they.
But it wouldn't lessen our position any if we requested AG opinion. But you said it'd take several months anyway.
Well, I don't know if
It
it's
would
less
show
than
them
I
that we're serious about exiting this contract possibly.
Well,
Could
you know what?
work in our favor.
This is what I say. I don't know. If I'm putting my ATS hat on, why would they think we're negotiating good faith if we're still kind of, in their mind, I think this business model doesn't work for county. I've said that to y'all, public and an executive. It doesn't work for counties. City, home, that's a totally different thing. They would feel like if you're in negotiations, part of it is negotiating to settle it like it is. If we go around and we get an AG opinion that's going to gut it, then we're not going to be able to settle it with this.
How would that do? That would better our position.
No, it's going to better our position, but since it guts in the negotiation for a number under our thing,
They still have to agree.
they have to agree to those other terms on that indemnification. No, it strengthens our position, but we don't want to win the battle and lose the war. Because the war is to be out of this and not have damages that are untold that you pointed out, and you pointed out, and you pointed out. Beyond this, the mutual release cuts the bleed. So they would maybe say, well, okay, you wait on your AG opinion, and then you have to, we'll see what y'all do in court. Because I think that there's some people want to minimize whatever's going on in ATS and the back press, but I think there are other entities that would love litigation. So I think they're kind of a house asunder, but not my problem. I don't care. Somebody, you just have two competing interests.
Judge White, the opinion, AG opinion would come from the state of Texas Attorney General, right?
Sure.
Oh, well, ATS is in another state, they wouldn't even probably recognize that AG opinion.
But we're venue and jurisdiction lies here, so it would control here.
They're controlled here.
Their argument would be that it requires.
That's what
So
they
we
say.
need to be in court to actually have a ruling on it.
And frankly, I think Rebecca spun it out pretty good when we're talking. The judges are going to do what they want locally here, but I think we're on pretty good footing. But we have to offensively file the deck. We have to do all y'all know, y'all been in lawsuits, the attenuated things that go with that. And then, even if we prevail, don't get the damages. Then we get the cases that appeal. I mean, they're going to appeal. This isn't going to go away just because we decide that we get an AG opinion that's favorable. Then they're going to appeal it.
It's really just, if you can calculate that amount, obviously that would make it a lot easier, because then you can compare the options just surely financially.
Yes.
But that's the number one benefit of the termination agreement, is that you know what it is.
Yeah, and I think we said that. And that it's under what's been collected, I believe, certainly. And I believe it's still, my opinion, it's under what you gave us authority to communicate back to them. It still may be more than what we want, but that's why we're settlements. And most of these are done, confidential, but y'all decided to do make it public, so we'll make it public. That's our number, that's where we are. They asked us to hold that as a proprietary number, and we say that we're not, and here it is.
Well, my fear is that they're just toying with us like
they're playing with me, and I've got like 90% agreement. I mean, I got the agreement. So they do the 100% agreement. Y'all sign it, they sign it. They don't sign it, none of our other two roomies go away. What happens? I think we've got the upper hand in getting them to sign it. And if they don't, we still got those other options. Those don't go away. This one goes away if school starts and we turn the cameras off. They know our deadline is school year, is our budget. They know that. They didn't really know because this was put on late because we really wanted to be 100%. But in the absence of getting 100%, I said, but hey, with it, let's go 90 so y'all get an idea of where we are. And that's all I know.
I want to say something. You know, we're sitting here talking about this. We've got a couple of serious issues here to look at with this. We don't have this contract in our budget. That's the first thing. And we're doing bonding. And visiting with several people that are serious about buying bonds and things of that sort. We're putting ourselves in a situation that's not good for the county by selling bonds and not telling people the truth that we have a financial obligation that we've got the county into, and we're talking about sitting here paying it. Let's get us that AG's opinion so that we have a little bit more leverage for you with these people at ATS. I think it'll give all of us some clarity on what's going on. We spent one time, when I was on Commissioner's Court before, I'll tell this little story. There was a $25,000 item issue that come up in this county to not pay this attorney $25,000. And we wound up spending over $900,000 fighting it out of county money, out of county coffers money. So I don't see fighting an issue being much, we'll challenge it if we have to do our attorneys, and you're quite aware of what I'm talking about, the case and what went on there. So, in order not to pay a $25,000 item case that we could have got out of just reelings, and I said,
well, I understand all that, and it's your choice.
Yeah,
I mean,
well,
it's
like I said,
but I will. The only thing I would disagree about is once you have a release, there's nothing to carry forward. But I'm not your accountant. I'm not a CPA, and I don't do audit. So there's nothing to be realized as far as the future in bonding if it's done. Okay, if it's over. Now the AG opinion, if that's what you want, just because you want it, then you want it. I mean, there's nothing. Don't argue with me about it. I'm just telling you that it still puts you in a defensive posture. Once you get it, then we decide we want to sit on it or not, but we have to, with that opinion, do something with it. And we are on offense, not on defense. When you're on offense, we went through the government, you lose sovereign immunity. It is what it is. And we might be successful years down the road. And what's important about that case is perhaps, hindsight's 20/20, the $25,000 and making a principal, as opposed to the hundreds later. I don't know what's better. I don't know what was better. That's up for you, because you have all that information and you have the advantage of being the decision maker here, and I don't.
I don't want to pay anything.
Well, that's a decision.
That's where I'm at.
Okay.
That's where I've been from the beginning.
That's a decision. And realizing that paying them nothing means that money that we realize as net proceeds is an argument of paying nothing if it's within the proceeds. But your argument is, I want to take that $198 and leave it sit over there in a line item and pay him nothing.
Well, that's a good point. Judge, did you segregate all this fund money in a specific account, like your analysis suggested? Is it in a, we still have it, or is it spent? Where is it?
I didn't hear the first part of the question, so.
Is all the money that we've collected from ATS, is it in a account? Like,
Yeah, we transferred it to the general fund.
no, I mean, so it's just from this general fund, it's not.
It's in a specific line item that says ATS contract revenues.
I understand that, but do we have it, or has it been spent through the last 2 years?
Hasn't been spent, no, sir. We've,
So you got it budgeted in one line item that says ATS revenue?
we have recorded the revenues and the expenditures, and the net was the 198.
But it's not in a separate account or line item by itself.
The revenue is in a revenue and the expenditure is in an expenditure account.
In with the general fund.
Yes, sir.
Okay, so it's not segregated.
No, sir, it's in its own line item.
Back, okay. Whatever. Check my phone. Any other good question? Those are good questions.
I don't know what Ken's thinking. You got me confused, so I'm trying to.
What's?
Well, I don't want to pay him anything either, but are you saying that, you know, we don't want to do like they did in the case before, we should have just paid them up front?
No, he's saying the opposite of that.
Or not?
I'm opposite of that. I
Yeah,
don't
he's saying
think
the opposite.
anything.
So you'd rather pay the 900,000 than you would the 25,000?
Probably would.
On
That's
principle.
what I'm just asking.
On principle.
Yeah.
So the item here that we're discussing is considering a resolution or the options for ATS.
Right.
Do we need to take some sort of action on that before we
Yes, we
move
do.
to item two?
Well, I don't think we can move item two. And the reason I say that, but I didn't want to pull the whole process.
Right.
If you guys want us to move forward, we've got to make the terms. I think we can nail this down. Rebecca said a week. I'd always say 2 weeks. Yeah, anything can happen, and put it on, let's push it forward, 22nd. Put it on the 22nd with the final agreement. But if you vote and want the other two options, then we can quit going back and forth with them and just say, we're going another way. I mean, I would say nothing. I mean, just won't come to calls. Or something, we'll do something. We don't want to be unprofessional, but I'm just saying, we would let them know that we work in this arena at your behest. And if it's not your desire, there's no reason us just beating our head up and keep talking to them about something that's not going to happen. That, I think, gets us in a, that's what we look like we're just playing with them, and that we're not, because they probably in their mind feel like they're operating in good faith, and it's a good business model, we're all wrong here in Texas. That'll be resolved some other day. I'm just trying to figure out which way of the three options that we were presented with, because I really did think about in detail the other two, the ones you mentioned through Rebecca about go ahead and get the agenda, and I'm like, okay, so let's play that out. Then talking to Win and Win, just do nothing. So now it's not just the one option. We need to know, which one are we moving forward on? Because if we're moving forward on the other two options, we can quit negotiating with them and work on some of your other projects and just wait.
So back on the issue of the 198,000 or so that Karen says we've taken in on fines and fees.
That's what I've been told.
Yeah, and I mean, that'd be easy to verify.
It's true.
Yeah. So, they have asked for 175,000
To settle it would be 175,000 to settle it.
plus 63,
$6,800
$6,800.
for removal of their stuff.
And that guarantees there's no other, they're not gonna come back and ask us for anything if we approve that settlement.
They can't. It's a release.
It's a full release. There's nothing for them to go at.
That's exactly why we asked Win for
Another opinion.
look at it, because that's where we believe it was at, and they verified that.
That's, you know, if it's signed and executed. The only, to me, there's some work we can do. The big issue for done is indemnification against third party. I want to protect the county, and I don't mean that individuals, now I'm speaking to the collective body, the taxpayers. I'm talking about the taxpayers, protect the taxpayers from a third party action, much like we talked about Hayes. Because if they are out, I don't get the advantage of stepping back and going, y'all can do it out. I gotta stand in there and agree, and I'm trying to stretch that out if I can.
So there is no chance they can come back and say, you owe us $500,000 because of the contract, because it's
It's a settle and release.
Right, and the second option is, that Win and Win said, it's just do nothing and just sit there.
Win and Win went through all the options. Nobody's gonna recommend to y'all what to do. What Win and Win said, and they could have come here, but I didn't.
Right.
that
I'm glad you did.
everything that we saw in the settlement up to this point was exactly like what Commissioner's office was saying, well, maybe they're going to give us this $500,000 later, or all you those things. They said, no, it is what it purports to be. Here are some other areas that we think we all need to, lack of a better word, tighten down, hone down, and we just didn't have enough time. We ran out of time when we wanted to present something to you today, because this all came up, and we can, but once you tell me, I think Rebecca can get with the general counsel there. I think a vote in that direction lets them know this is what y'all think about. And in fact, if the vote in another direction, we just say, sorry guys, it's not happening.
All right, and on the third one, is that the one where we would request an attorney general opinion?
Yeah, well, there's briefs, like you're saying, that was what went and went, and attorney general opinion. The only attorney general opinion, and I was saying, based on some of the cases, and I think Commissioner's office was kind of talking about maybe what's happening in other counties, and kind of looking at all these parts and how they would play together, is that we get that opinion, and then what do we do with that opinion? And we have to act on that opinion if we get that opinion. And we have to follow declaratory judgment, find that it's unconstitutional, based on that opinion, which would be advisory. So that means, if we're just going offense and defense, okay, once we step up as an offensive player, you lose your cloak of sovereign immunity, okay? We're no longer, and you have all the damages. You have all the damages. And it's kind of though, I think what Commissioner Shane is saying, even though, stop me if I'm wrong, even though the damages upside might be higher for you, in your experience, it's the principle because they will be found unconstitutional, even as opposed to limiting the way it's other because it's the principle. Am I mistaking that? So that's why he made the analogy with another case years ago. And again, with those options, that's fine, understanding that there's actual damages and there's also other kind of damages. I mean, they could go with the tortious act. If we did that, I mean, how does that happen on the
So, one,
you're getting third-party claims, it's going to be a legal free-for-all.
so just one final question that I have, and then the court may have, I'm sure we may have others, but the quickest way to exit this contract is to agree to pay them $175,000 plus $68,000, $6,800 for their equipment. And then we will have somewhere around $200,000. So that's been accumulated since the beginning of the contract. And so that's the quickest way to exit. And there's some details that you and Rebecca need to work out, like you discussed with us.
Right, and the details can be brought back into a commissioner's court on August 22nd to work out. We won't be going backwards with 1, 2, and 3, and that's why I thought. Now, how about like what Commissioner Dog said? They're toying with us, and we go to them and we have everything except for something that we think is vital. Then we would come back and say, they didn't do this and we think it's important. And then it would kind of, the settlement would go away. I mean, or you could decide to continue to do it and balance that against those choices. I'm not saying it's done, but I think we're pretty darn close. And so that gets into just, oh, we take something for you to sign. Or, you know, we circulate, we just bring it back to court and go, hey, they agree to everything else. I think we're protected. We've got this clause in here. We might do a little executive if it's something I don't really just want out there. Then y'all know it's in the contract, you know it's substantially the terms, and then you can vote on it. But if you decide to go the other way, then we can just, then y'all just decide which way you want to go. Even if you decide, I don't really want to, I mean, just want to go another option. What does it say, other options on the agenda? We have to pick one.
Resolution options,
Yeah, so it can just be, we'll do the resolution and resolve this as an, I'm sorry, we could do the agreement, or we can do other options. And that's something we can discuss at some other point later. We don't have to do that here, open something else.
Jackie, you have?
You know, yeah, if this, and it is me, this is county, if we can settle it, now I can, sometimes Crystal comes into it, but we can't let 45,000 grow to $1 million and put it on the backs of the citizens.
That's exactly,
When we can do this if we can't lose our sovereignty, and we're about our immunity. We gotta protect that. And if we can settle it easily within a week or two, then get it gone. I mean, we can kick this can on down the road forever, and it will never end, because they have a lot more money we do.
Right, well, and the direction that I got from you guys was, again, that we had been directed at some point back in the future months ago, and it's no secret the popularity of ATS in our county, it's no secret. So it's like, what can we do to get rid of it? In fact, it's like, well, why did you do it to start with? I mean, we've had the whole gamut. So now we're back at, here we are, how can we settle it? And the only thing I had to get from y'all, because I don't represent the county as far as numbers. Y'all are the purse strings of the budget. Here's a number, and it has to be under what we got in net proceeds, or we're not talking about it, because I'm not going to pay over and above what we made in this program, excluding the fixed cost that it's all cost us. Got the marching orders, got to working on it, accomplished that. This is a response to that request. But as any contract, negotiation, or a settlement of a contract, there are more the more you read of terms. That's why it was worth getting another set of heads in it. So we want to finish it, and we have told them, really, we're trying to finish this before budget because of some of your concerns about bonds and some of these other things, bonding things, and just so we'll get it behind us. We don't want it to go on forever, and we don't want it, from what I got from y'all, on when school starts, in September.
So through the negotiations is the quickest, simplest, easiest way to get this accomplished.
Right now,
And in 2 weeks, if we don't have it done, then we have our other two options.
Those other two don't go away. I mean, they don't go away. And I think the only thing that Commissioner Rizal is saying is that you can do two things. You can settle into the AG. And I think that when you're negotiating with somebody to resolve something, we need to finish that. And if we can't resolve it, then I think these other issues are still relevant and right. I would just say, if I could put myself in their shoes, I don't think that's how you negotiate with them, going, beat them over the head with some leverage, because, negotiation is different. When you go to court, it's all holds barred. But when you're trying to settle something, it's, let's work this out. I mean, it's a different dynamic. I mean, y'all know that. You've settled deals before.
Kevin, if you have any other comments, what's the matter?
We'll give them plenty of time, we'll give them till August the first to get this done, and if they keep playing y'all wrong,
When did we do that?
I'll go with you another couple of weeks. Yeah,
I think
I'll
we should give
a
2
couple
more weeks.
more weeks time.
See if they can come up with
Well, they haven't,
well, these are finalized.
yeah,
What we're doing is not.
I'm sorry, I just can't see wasting taxpayer money going down the road, spending $500,000 or $600,000 down the road, or leaving it for the next generation to deal with for the next 10 years.
Any commissioner? Anything you'd like to add?
If they can settle it the next 2 weeks, I think that'd be great. If they can finalize the details.
Okay,
I'm just saying.
ladies, y'all have heard the commissioners.
We'll say it's finalized.
Yeah.
We're saying.
Everybody-
Couple of weeks, get it done.
I think is on I believe we're on the same page, and we're going to finalize in the next 2 weeks, based on the option of exiting the agreement and getting all the lawyerese stuff straightened out in your opinion. So what you need from us is some sort of an action. It says resolution here, consider a resolution. I don't have a resolution. Could you help us with that?
Resolution or a,
Ms. Martin,
Well, she's going to go to
she wants the resolution. They just continue to negotiate like they are and get the wording the way they want it.
along the
He said the right
option
thing.
one.
Releases.
He said the right thing, to give us the authority to continue negotiating the termination agreement.
Along the items of option 1 that we discussed.
Yes, well, I think it's clear along the items of settlement of termination agreement, settlement of termination, so it's not clear. Yeah, to be clear what it is.
it's the 22nd, regular meeting, you think we should have it wrapped up?
Well, I mean, I think we should. If we don't, we'll tell y'all, and if we're, come back and, it's like this. They should want to settle it too. I mean, there's all the things that y'all discussed that are at our disposal, even though it puts us in a bad position, I think, they're still at our disposal. And we will act on those things if they're not willing to come on with it. The things we've got left, they need to finalize.
Coincidentally, that's the first day of school, I think, for
Well,
most.
good, we can make sure.
Most schools in Kennedy, I believe, so. Gentlemen, do I have a
That would be a
motion
lot.
to proceed? Yeah, we can, if you get it done earlier, we can. We'll be meeting anytime.
Call it, I mean, it's 72 hours.
We will use August 15th, just to give us a
It's
little.
okay, we're having a special meeting then, anyway, so if you get it done by then, we can have it on the agenda for that item too.
I won't be here for the only reason that y'all can do this without me. You don't need me, I'm taking care of college.
Okay, do I have a motion to proceed along the lines of, oh, you already made it? Commissioner Allen made the motion. Commissioner Phillips seconded the motion. Further discussion? Did you have a question?
He said there came on to be considered a motion to approve giving the district attorney the authority to continue negotiating the termination agreement? Okay.
Okay. Any other comments before we vote? All in favor say aye. Aye. Those opposed? Thank you very much. Now, I guess item number 2, we don't need to.
We do not, because we can't take an action on a contract that's not complete.
You got what you need right now.
Yes.
Okay.
2 is not ready for y'all.
We have a motion to adjourn from Commissioner Phillips. We have a second from Commissioner Allen. All in favor